been severely impacted by this crisis. In Clark County, opiate use and misuse were implicated in over 1,700 emergency visits and 1,700 inpatient hospitalizations annually from 2013 to 2015. In 2015 alone, $13 million was spent on emergency department discharge charges, and $94 million was spent on inpatient discharge charges in Southern Nevada. That is equivalent to the cost of providing more than 4,200 people with inpatient treatment at an average price 28-day drug and alcohol rehab center. The drug companies knew their marketing and the way opiates were prescribed was contrary to the scientific and medical evidence, and their misrepresentations have been confirmed by the FDA and the CDC. Now, some drug companies have entered into settlement agreements with public entities which prohibit them from marketing or from making those false and misleading misrepresentations in those jurisdictions. In our community, however, opiate drug companies continue to misrepresent the risk of long-term opiate use, and they have not corrected or changed their past misrepresentations. Cities all over the country have already filed civil lawsuits, and many more counties have already filed civil lawsuits. It is important for Clark County to get into this litigation and file a lawsuit as soon as possible, quite frankly, to move up this line and get this matter resolved. Clark County is wise to bring its own case because, one, we have a more favorable forum in our state district courts where jurisdiction for this case resides. Two, the county commission and the district attorney will have more control over the litigation. Three, the county commission will have discretion over how settlement proceeds are allocated. And four, Clark County is likely to have a larger settlement amount if we get into this litigation and file our own lawsuit now. Nevada has the best product liability laws in the country for plaintiffs. It's what I do. It's what I've done nearly my entire career. And I'm aware of what the other states' product liability laws are compared to Nevada's. And they're the best because, one, Nevada endorses public policy in favor of protecting consumers and its citizens. Two, our strict liability laws are favorable to plaintiffs. Three, comparative fault is not a defense in product liability cases in Nevada. Four, Nevada has not adopted the learned intermediary doctrine, which allows the drug companies in many states who've adopted this doctrine to simply blame the prescribing physicians in escaping liability. And five, Nevada has no cap on punitive damages in product liability cases. Clark County is also wise to bring its own case because if the state of Nevada joins other states and files a joint lawsuit, the case will end up in federal court where obtaining a favorable verdict for plaintiffs is much more difficult, or Nevada will get lost in the shuffle and receive a much smaller share of the recovery, which means less recovery, if any, to Clark County. For example, in 1998, the Attorney Generals of 46 states, including Nevada, signed the Master Settlement Agreement with the four largest tobacco companies in the United States for $206 billion. Nevada only received an estimated amount of $1.2 billion because we did not file our own lawsuit. Florida Minnesota, Texas, and Mississippi brought their own lawsuits. Texas settled for $17.3 billion. Mississippi settled for $4.1 billion. Florida settled for $11.3 billion, and Minnesota settled for $6 billion plus $200 million per year in perpetuity. Clark County's damages include: 1, costs expended by Clark County related to opiates; 2, all costs extended for healthcare services and programs associated with the diagnosis and treatment of adverse health consequences of opiate use, including heroin and including opiate and heroin addiction. 3, all prescription costs for opiates Clark County has incurred as a result of the defendant's wrongful conduct. 4, costs incurred by Clark County to investigate, apprehend, prosecute, and incarcerate individuals who have resorted to criminal acts regarding prescription opiates and heroin addictions. 5, future costs to continue to provide services and programs associated with the health consequences of opiate use, including opiate and heroin addiction. 6, punitive damages. 7, an order mandating medical monitoring for Nevada opiate users. And 8, an order restricting false future marketing practices by the opiate manufacturers and distributors. My firm, Pt3, will advance all costs and expenses of the lawsuit. We have budgeted $15 million for the cost of prosecuting these opiate cases and have set that money aside. Therefore, Clark County is not at risk, nor will any of its resources have to be used to prosecute this case. My firm will advance all the costs of the litigation and take all the risk. We have handled many large cases against drug manufacturers and distributors in the past. We are very familiar with the pharmaceutical industry, their business practices, the potential defendants in this case, and the law firms that represent them. 2 of the biggest defendants in this case will be Teva Pharmaceuticals and Makessa Pharmaceuticals. Those were the 2 primary defendants in the hepatitis C cases that I handled here in Clark County, and we tried numerous cases against with great success. So they know us, and we know them. And we have been successful against them every time. We have obtained, my firm, the largest injury verdicts in the country twice, in 2010 and 2013. We obtained the 3rd largest verdict in the country in 2001 and the 39th largest verdict in the country in 2007. Without sounding too boastful, I was told I actually have to say this, and I'm uncomfortable about it, but I'm the only trial lawyer in the country to ever obtain the largest injury verdict in America twice. I'm the only trial lawyer in America to obtain 2 verdicts in the top 5 in 2 consecutive years, and the only trial lawyer in America to obtain verdicts in the top 5 in the country 3 out of 4 consecutive years. I've obtained more multi-million-dollar verdicts than any lawyer in Nevada history, and I am the only lawyer in Nevada to ever be named Trial Lawyer of the Year twice. I was honored as National Trial Lawyer of the Year in 2013 and National Lawyer of the Year in 2010. In 2014, the National Law Journal, the largest legal publication for the legal field in the country, named my firm and it to its hot list of the 12 best injury law firms in America, and also named Pt3 as one of the 50 best trial firms in the country. We have a national reputation of handling large cases, outworking the other side, and obtaining outstanding trial results and settlements for our clients. Our reputation benefits our clients because it leads to larger settlements and usually quicker resolution. 3 of my senior partners, including me, are lifelong residents of Clark County. This is our home. This case is not only professionally important to us, this case is personally important to us. Because we, like everybody else in this community, have been affected through family or friends or coworkers by this epidemic, this opiate epidemic, which caused a significant portion of the heroin epidemic in our community. We are a local firm with strong relationships with the Nevada judiciary, and we are prepared to allocate all the resources of our firm necessary to litigate this case to conclusion. I want to thank Chairman Sisolak and the board for your time today, and if you have any questions, I'd be more than willing to answer them. I'd like to ask, with the board's permission, for my partner, Robert Adams,